The Supreme Court ruled today that part of the voting law that in 1965 became a major turning point for black voters in the United States as far as access and power is, as of today, outdated. Specifically, the court ruled forcing Texas and a few other states to get federal approval of all voting decisions is unconstitutional. Fox 4's Sean Rabb in our Dallas newsroom tonight with more. Sean.
Yes, Steve, the ruling makes it tougher for federal officials to prevent states and localities, primarily in the South, from adopting policies that some see as adding barriers to voting. Longtime civil rights activists feel like the strides made over the last many decades have been lost.
It's very painful for me. I have friends who are in the graveyard for the right to vote.
By a 5-4 margin, the Supreme Court ruled the provisions in place inside the Voting Rights Act that determines who needs to have the right to vote protected no longer apply.
I think the Supreme Court's ruling today is a fundamental rejection that states in the southern part of the nation are fundamentally discriminatory.
Texas and other states with a history of voter discrimination had to seek pre-clearance from the Justice Department before making any election changes, like moving a polling place or redrawing district lines. That all went away today.
Basically, you're making the Voting Rights Act a toothless tiger.
And Texas has wasted no time making changes. In an email from the Department of Public Safety, pursuant to a U.S. Supreme Court ruling issued today, new voting requirements passed by the Texas legislature in 2011 will take effect immediately. Photo identification will now be required when voting in elections in Texas. Again, public policy lawyer Marcos Ronquillo.
The Supreme Court, they're declaring Section 4 unconstitutional, basically guts, undermines, it pretty much eliminates the Voting Rights Act as we know it.
What may have been true back in 1965 is no longer true in 2013. This is a good day for all southern states, all states who want to have control over their own elections.
If you think you can trust the state of Texas, Dallas County to draw fair lines, giving everybody equal access to political power, then you're naive, blind in one eye, can't see out the other eye. That's not going to happen.
Now, the court said today that the formula used to determine what areas would fall under special federal monitoring was based on more than 40-year-old data that did not reflect current racial progress, and that Congress could come up with an up-to-date formula for deciding which states still need federal monitoring. But many speculate that's not likely to happen, Steve.
All right, Sean, a lot of questions here, and
okay.
let's start with this one. Do you get the sense that people think the entire Voting Rights Act was overturned today? I mean, voter discrimination is still illegal, right?
Voter discrimination is still illegal. People do feel like the entire Civil Rights Act was overturned, with Section 4 being overturned, because Section 4 was the formula that you superimposed over the states to determine which ones needed to have special monitoring based on the population of voting age people of ethnic groups, as well as those who speak a different language. So yes, many people feel today that it went out the window. I mean, yes, it's still in place. Yes, you can still sue, but you don't have the support of the Voting Rights Act to challenge anything in court. You have to use the 14th Amendment.
Tell me if you read this, how I read this pre-clearance, this Section 4, having to get federal approval. I got that the court thought it just took too long, and that was one of the problems they had with it.
That is one of the problems that they had with it. You know, you have to go up the chain, you have to go through the appeals process, and then there's a 3-judge federal panel that reviews it before it goes to the Supreme Court. So yes, that was part of the problem. The other thing is, though, Steve, they simply said, look, there are more minorities registering to vote and voting. And so we believe that the model used previously to determine people being discriminated against is a dinosaur and no longer needed.
Interesting. I thought the one African-American on the Supreme Court, Justice Clarence Thomas, he said he would abolish the whole thing, right?
Yeah, he wants to throw the whole thing out, feels there's no need to have it in any way, shape, form, or fashion, and feels we're at a place now where states can take care of themselves fairly and equitably. Many people, though, still don't feel that way.
All right, Sean, we'll see how it goes. Thank you.